Hello.
Hey,
That was a loud hey.
we are here
We are here.
live.
Yep. We're excited. We're back.
Yes,
Um, we are. What episode is this, Richard?
8. I actually believe it's number 8.
You think so?
I believe so. If I'm wrong, ooh,
Okay,
I
so
believe it's number 8.
season 3,
You got me curious now.
episode 8. We will be discussing mental capacity when it comes to drafting certain legal documents.
Mhm.
The certain legal document we'll be speaking about today is the lasting power of attorneys. Just to say what the lasting power of attorneys is, do you want to describe what it is, Richard?
Yeah, so a lasting power of attorney is a special document valid in England, Wales, and Scotland, um, governed by the Mental Capacity Act. And I always say it like this: there's no such thing as a next of kin. Once you reach the age of 18 plus, then you're an adult, and so therefore you can make your own decisions. And so therefore the law will not allow for next of kin, family, friends, loved ones to make decisions in the event that capacity is lost, either temporarily or permanently, for certain aspects of life and situations in life. So predominantly health situations. If you're unable to speak for yourself, then without this document called a lasting power of attorney, then the local authority or medical team could veto your family's wishes for their welfare and for their health decisions, and also for property and finance decisions. It's that same thing. If you own property or have any financial instruments or bank accounts, etc., if you're not able to speak and that document is not valid, then a court order, the court protection specifically, will have to get involved to allow someone or a group of people to make decisions, and very specific and rigidly what kind of decisions can be made or not made. So effectively, it's very vital that everyone, we say that it's better to have it and not need it than to need it and not have one, gets a lasting power of attorney document, both for health and welfare and for property and finance.
Thank you so much, Richard. So now with the basics of what the LPA is, we're going to go into, just before we go into the different types of LPAs, we're going to speak about mental capacity. So it can be quite a complex area. What it is to draft any type of legal document, really, you would have to be in a mental mind frame to make those type of decisions.
Yeah.
So if, for example, there's dementia that we come across quite often, things, if you have mental something like dementia, we would need to assess if you have the mental capacity to make those decisions. Sorry, I've mumbled up my words a bit, Richard.
No, I mean, exactly what you're saying, and to back up, and to back up what you're saying as well.
Yeah.
We need mental capacity to make many decisions.
Yeah.
Some, the capacity is much higher, a much higher bar than others. For example, the mental capacity to get married is far less than the mental capacity to draft a will.
Mm-hmm.
Yeah, as will writers, as professionals, as lawyers, we have to assess: does someone understand what we are saying? So we've got mental capacity, we've got, I keep forgetting the term, knowledge and approval. So do they know what they're doing? Do they approve of it? Which is not, it's kind of a little bit different scenario of mental capacity. It's more about undue influence. But then do they have the capacity to know that they're actually gifting something away to loved ones, and they understand why they're doing it, what they are giving?
Mm-hmm.
And as professionals, we have to make that assessment because we're held responsible if it's not.
Yeah.
And then even in a high level of like a trust, do they know what they're doing? Do they understand how it works? So signing deeds, signing any kind of documentation, do they have the actual capacity mentally to know what they're doing?
Yeah.
So that's one side of the coin.
I do now recall what I was trying to say, but I wasn't communicating it as well as I should have. So one reason why LPAs are in place is due to mental capacity. Um, if you do not have the mental capacity to make a decision, in your LPA, you would document who you want your attorneys to be, and those are the people that will make decisions on your behalf if you are not able to. So let's say someone's in a coma, they aren't communicating, or someone's had a stroke, and they need somebody to make decisions for them based on their health and welfare, or their property and financial affairs. Then the person who they have named on the lasting power of attorney is the person that will make decisions for them. They can make decisions in different types of ways. It's jointly and severally, right?
Yeah.
And you can have up to 4.
Yeah. And then you can reserve
The
attorneys.
replacement attorneys as well. That's what I was trying to get out earlier.
So-
But yeah, so just to go to how it is assessed.
So yeah, I mean, the first thing I would look for is to actually understand what we're talking about. And mental capacity is a very delicate area. The law says that everyone is deemed to have capacity until proven otherwise. Mental capacity, even the average person can remember one thing today, forget it tomorrow, remember the day after, yet alone being diagnosed with something formal. Then you've got people who may have certain challenges. It might have been a car accident, and so things are a bit sketchy, or they can't speak verbally. Doesn't mean they don't understand. Doesn't mean that they don't have the capacity to understand what you're saying, even though they may not be able to communicate back to you that they understand what you're saying. So they need someone to interpret on their behalf. So it's a very delicate subject. You cannot presume someone to not have capacity. And that's the challenge. Yeah. And you can't assume because someone's got a label of doctor or nurse or whatever that they understand. They need to be licensed, especially for something as delicate as testamentary capacity or having the mental capacity to sign a lasting power of attorney documentation. Do they understand what's being said? And so as advisors, we have an interesting time of when people are coming to us saying, well, dementia has been, early onset dementia has been diagnosed. What should we do? Some people can take the approach of panicking, not touch that client at all. We don't take that approach. It's very, very delicate subjects. And so what we're saying is never not ask the question in terms of an advisor. But please be aware that at every given time, capacity must be assessed. And the advisor's job is to make sure that they are happy that the client understands exactly what transaction they're getting into and why. And they can, the hot word is contemporaneously document. So whilst the conversation is being had, document reasons why, situations, arguments for, etc. What questions have been asked, behaviors. What behaviors did the person display to make sure you were confident as an advisor that they understood? Were they by themselves? Were they helped or assisted? Did they look confused or not, etc., etc., etc.? And if there's any shred of doubt, then we ideally have a professional to carry out either a testamentary capacity test, if it's just for a will, or both from a testamentary capacity test and a mental capacity assessment to assess levels of mental capacity, is whether they can go ahead and do the transaction at all, whether that's to sign a will, trust, lasting power of attorney, etc.
Thank you so much. So we're going to now shift the conversation a little bit more to the functions of lasting power of attorneys. So there's 3. There's health and welfare, property and financial affairs, and business LPs. We're going to go through them one by one. So to begin with, the property and financial affairs, Richard.
Yeah. So it's as it says on the tin. It's there to decide how you want to manage your personal property and manage your financial affairs. So it sounds like I'm repeating everything again, but examples would be anything from the gifts. If you're already making regular gifts, say to charity, then you can assign an attorney to continue making those gifts. you can assign an attorney to allow investors to make investments or manage your investments on your behalf using a discretionary fund. And what's that limit? Is there a limit? Can they access your legal documents before or while an capacity is lost, etc.? There's different instructions you can give. Do you want one person to make decisions for one particular aspect of your financial life and somebody else to make decisions for another particular aspect of your financial life? Do you want it to be registered immediately or only when a mental capacity situation has been formally documented? What are the pros and cons of that? Should they be done? Well, I'm going into the generic side of it, but that's where the property and finance side comes in. Yeah.
Okay. Thank you so much. And the health and welfare.
Well, I'll say exactly the same. Health and welfare is a little bit more detailed in terms of you can give your attorneys the right to what's the word I'm looking for? Refuse life-sustaining treatment. So if you have particular beliefs or you're against certain practices or medicines, and your family and loved ones understand your views, you can give them the power to refuse or not to consent to certain things, which could sustain life. That's a major decision. Okay. Some people agree with it, some people don't agree with it. Again, your welfare, people like who know your lifestyle. So you may have a way of arranging your personal home. You might like to watch certain TV programs or certain colors. If you're, to relax. Same with your health. You may only eat raw foods or vegan only or vegetarian or pescatarian, or certain types of meats from a particular organic farm.
Yeah.
So they would know how you like to live. And so they would make sure that you've given them the authority to set things up in that way for your benefit. And again, if it's like contesting against local authorities and you've got these documents in place, it gives you a lot more power to veto decisions or to at least put your foot down in certain scenarios to get what you want. Without it, you're really very, very difficult, very, very difficult indeed. And even things like selling a home. Yeah. So for the property and finance side of things. So
thank you so much. And lastly, the business.
So a business LPA is more of a, I don't think a marketing speaker is the right word. It's a property and finance LPA, but if you run a business or businesses, obviously your family members and loved ones will understand how you live at home, but they don't necessarily understand how you run your business. And you may have a team of people who understand how you run your business and you trust implicitly to access finance, to speak to certain clients, customers, just make decisions running the business day to day. And if it means accessing bank accounts or speaking to accountants or paying certain bills, etc., and the family have no idea, you may want to nominate specific people purely for business or businesses only, rather than your personal affairs. So we class it as a business lasting power of attorney, but it's the property and finance lasting power of attorney specific for business only. Okay. And that could be all of your businesses or individual ones for specific types of businesses if you've got different types of trade.
Okay. Thank you so much. I think that's us coming to the end of our podcast, but we will have another podcast about LPAs going into more detail about it. But this was mainly to do with mental capacity and how that entwines with LPAs. So if you have any further questions, any feedback, please don't hesitate to reach out to us. We're always happy to answer your questions. But I think that's it, Richard.
Yeah, I think maybe one more thing that came to mind, just one. Trustees. If you're a trustee of a trust, it depends on how your trust is drafted, but trustees in general have to have their own capacity to step down. To remove them ultimately would go down to the court if the trustee themselves do not agree to step down, and that can be a major problem, especially if you've not been given advice around the trust. So highly recommend if you're a trustee to have a lasting power of attorney, because if the trust is drafted correctly, then you can allow the attorneys to allow the trustee to step down on the basis that the trustee's lost capacity. Really important to take that into consideration. I know people may not get the right advice around trust. So if you're in that predicament or situation, there's something worthwhile exploring as well. And I think that's about it.
That's it. Thank you so much, Richard.
No problem.
All right.
All right.
See you next week.
Cheers.